Hi and welcome back to my channel. So today we'll look at the movable property security rights. Now this is where two people enter into an agreement for uh, for using any movable property like a car, or some promise to pay note or salaries or such kind of things which you would otherwise not have a way to enforce them before as collateral for the payment of a loan that you have taken or any debt that is accrued. So this act, Movable Property Security Rights Act, was enacted in 2017 to enable the enforcement of and the registration of these security rights that are made using movable property, mostly according to the provisions of the Land Act and the Land Registration Act and the subsidiary legislation like the land registration, general regulations. All those were there were some sections there, section 78, if I'm not wrong, which talked about creation of charges where someone can use their property that is immovable property, like land and house, as security for a loan. So in this act today, we will talk about the creation of securities around any other property other than immovable property like land and houses. So yes, that is what we'll look at. So the act exempts the creation of charges and others which other laws apply to. Yes, so this law is specifically for movable property that is to act as collateral for credit facilities. And the objects of the act, as discussed in the act, to facilitate the use of movable property as collateral, so that there's now a register and a registrar and a register who now has been established by the Act to register security rights and provide for registration of security rights in movable property. So those are the objects of the Act. The Act defines under Section 2 many things and concepts which some of them are very hard to understand for me because they are like business jargon and like credit sale agreement, credit purchase. Some are financial terms and of accounting like receivables and others. So it was a bit challenging for me, but I'm gonna just mention the ones that I understood. So we have terms like collateral, which the Act defines to mean any movable asset, and also a receivable. For in my understanding of basic accounting, a receivable is any money that the business expects to receive from debts or from salaries, from any payments that are overdue. That is how I understand. So those two can be collateral for the payment of securities. Okay, for they can be used as securities for payment uh, of any monies or performance of any obligation under the Act. Then we have a term called commingled goods. These are mixed goods that have been used in such a way that they are unidentifiable or unseparable, then inseparable. So competing claimants, the creditors, competing claim on one or same collateral, credit sale agreement, sale of goods to pay purchase price in whole or part. This is how I understood credit sale agreement where somebody uh, pays for the product, pays the purchase price of the product uh, by surrendering a part of the product or the whole of it. Electronic security are not represented by certificate, so we have future assets being assets that the grantor, the grantor is the person now who is granting the rights to the property as security. Okay, so the grantor does not have any ownership rights or rights uh, to give it away, okay, when they enter into that security agreement. So maybe in future they will acquire those rights, but for now they don't hold them. Then we have a grantor. Now, as I say, is the person that creates a security right to secure either his own obligation or the performance of someone else's obligation, buyer, or other transferee, lessee, or licensee. So you can see here that the grantor is the person who uses that property, his property which he has rights. And one of the conditions that in the act is that under section 5, under section 6 is that the grantor has to have rights in the asset to be encumbered. So they must hold ownership rights. If not ownership, maybe occupation or possession rights, I don't know. So person that creates a security using their property movable is grantor. Intangible assets are receivables, uh, choices in action which are promises to pay, deposit accounts, electronic securities, and IPs. So in this act, it's interesting that IPs like copyright, trademark, the ones that goodwill of a business, I don't know, all those things. They are intangible, but they're still assets. Like when the example is when Nakumat chain of supermarkets closed down during receivership, everything that they had was worth it, including the trademark, Nakumat, the goodwill, everything, the name of it, all those could act as security for the payment of their creditors. Okay, so that is one example. So there's something called security certificate, which is defined in the act to mean the security certificate is the identifying document showing who the creditor is, the person is entitled to the security held in the property. It describes the grantor, describes the property, and the person entitled. So, secured creditor has a security right and transferee of a receivable. So, a secured creditor now is the opposite of the grantor, because the grantor, when the grantor gives the right, the secured creditor takes it. Okay, so he could be a transferee where we're talking about a receivable acting as a collateral. Like I said, a receivable from my own basic understanding of accounting and business. Business accounting is any monies due to come to the business. Okay, like payments of debts, returnables. I don't know. Like it's a whole different world. But if you want to understand more what they are, you can just Google. Security agreement is a transfer of a receivable, is the agreement that acts as the transfer of a receivable, outright transfer where it is a receivable, or an agreement that is entered into between the grantor and the creditor, the secured creditor, that is supposed to be according to section 6, supposed to be in writing, it's supposed to be signed by the grantor, it must be identifying the creditor, it must be describing the collateral and the obligation if in case of performance of an obligation. So you can see that basically this act is all about creating securities using movables as the normal way of creating securities using immovables like charges and all other things, mortgages. A grantor to have rights in the asset. That is one discerning factor, because if they don't have rights, I don't think that agreement will be valid. Duty to adequately describe the assets encumbered or to be encumbered in the security agreement. Okay, so that is section 8. Section 8 says that it describes the collateral. So the asset encumbered or to be encumbered shall be described in security agreement in a manner that reasonably allows their identification. The description that identifies collateral consists of all the grantor's movable asset or of all the grantor's movable asset within a generic category. A description identifies the collateral if it is identified by specific listing, category, type, and quantity. Obligations secured or to be secured shall be described in the security agreement in a manner that allows their identification. So basically, section 8 says that uh, you must describe the assets that you are making as collateral. If it's a car, you describe the car, the make, the make, the mileage maybe it has. You describe the registration, you know, the serial number, whatever it has about the car, the color, whatever category. So in a manner that allows the identification, the domain ought to be by specific listing or by category. A grantor or secured creditor in possession of the collateral shall exercise reasonable care to preserve the asset. Duty of a secured creditor to return the collateral. So there's a duty to preserve the asset, because remember, it is not uh, transferring the ownership unless there's default, because you are holding it as, you know how you go to what can I say, how you take loans and you use your property like gold jewelry, and you need cash, so you just give it away, then you take it back if you pay for it, something like that. It's normally an informal process back home for small items, maybe TVs, or but here we see that even cars that could cost millions can have their security a security created. Also, we have so there's a duty. There's a duty here on the part of the creditor to preserve it and also to return it, to return the collateral to register an amendment or cancellation notice as provided in section 33 and termination of a security right in the code. So the security itself is not informal anymore. because this under Section 6 it's required to have an agreement, a security agreement in whatever form, but it should be in writing and it should identify those particulars of the property or asset to be encumbered, the creditor, the grantor should sign and everything. So that security agreement doesn't end there, because in order to enforce it, it has to be registered, okay? And we'll look at the process. Let's look at the process quickly. Secured creditor. Okay. So just before we look at the process, I would like to say that this act has repealed the Charters Transfer Act, which was the one before this one. Charters means any property that is movable. It's not fixed. It's not a fixture to sorry, it's not an immovable, but it's movable. So any charter that was used as collateral was regulated by this act, which is now repealed by this one, the Movable Property Security Right. It amended the several provisions of the Agricultural Finance Corporation, because remember, I forgot to tell you, one of the items you can use in this act to create security are crops, and crops falls under agriculture and the Agricultural Finance Act, this one Corporation Act. So it has amended some provisions here. The Stamp Duty Act, because apparently it also talks about this, we'll look at it. And then we have the provisions of the Hire Purchase Act. This one, hire purchase, how it's about the where you pay in installments for until you complete. Failure to complete leads to surrender, or what do you call, forfeiture of the product. Then we have the Pawnbrokers Act. That's why I'm telling you, before you could just simply use this Pawnbrokers Act or Chartered Transfer Act when you're creating security using items that are movable. People will send their furniture, their wealth, and pawn them for some much needed cash. So it's like pawning this whole business, but it's more sophisticated because now it introduces a system of enforcement and registration, accountability, notices, certificates. So it's quite formal. Companies, then we have business registration service, also amends a provision there, Companies Act, several provisions, Insolvency Act, and a lot more provisions and insolvency act amended. So okay, I want to look at the whole creation thing. Then you see now this act provides for the perfection of a security by way of registration. Okay, so mm, now we have under section 2 of the act, we have defined the registrar, which means the person appointed at Section 19 to supervise and administer operations of the registry. Section 19 establishes the office of registrar, which shall oversee general running of the registry. And the functions are to receive, store, and make accessible to the public information on registered notices with respect to security rights. Rules. Okay. Section 3, the registry shall be electronic. Submission of a notice under such request to the registrar shall be by electronic means. Collateral means, that one we have defined. Notice means communication in the prescribed manner to the register of information in an initial notice, an amendment notice, or a cancellation notice. Submission of a notice under such request to the register shall be by electronic means. So, Section 27 is explaining how to make that notice. Procedure for registration. Yes, let's look at. So the security agreement under Section 6 that includes the sign of the grantor, the property description, the creditor identification. That agreement is in written form is the first step, which you will use to create a notice on the register. That notice will inform all other people of the security that is created against it, like an encumbrance. It's like when you register a charge on somebody's land, the perfection of the charge is paramount to its later enforcement because to the preservation of the property and prevention of from it being disposed by somebody else without your awareness or consent. So the first step to perfect the security is by way of having that written agreement signed by the grantor showing to the registrar, okay, that this property is subject to our security. And then there's a notice that the initial notice that is that you put like to encumber that property and to also inform others that the property is subject to a security right. So registration of an initial notice, that is section 24, or an amendment notice that either as collateral not included in the security agreement or another grantor is ineffective. So the security agreement is very paramount because whatever you describe there, you can't add something that's not there. Okay. Mm, yeah. So the written agreement will be sufficient evidence that the grantor has assented to the registration or has authorized the registration of a notice. The procedure for registration of a notice is access to information by the public conduct of such an assigning of unique identifiers to grantors and security shall be as prescribed in the regulations. Now let's just check. You know, the good thing about subsidiary legislation is that that is where now your answer is basically how to do something. The act will tell you what, but the rules will tell you how. And I love rules more than acts sometimes because some acts can't contain every detail, but the rules on the other hand, they don't mind telling you how to get up and where to go and what to do and what to write, which documents to file, and I really enjoy them. I really love them. Let's just look at them. These rules, not seeing them. I need to see the rules immediately. Can get on them. Okay, let me just, I'm not seeing the, it's just see this, there's this handbook. There's this handbook of movable security rights creation. Let's just look at it and learn something. So there's a handbook on the Movable Property Security Rights Act by the Business Registration Service. It's 2020. Okay. So I'm interested in Chapter 2, Overview of the Act, 2.5, Creation of a Security Right, and Registration, that is 2.8 of Notices. Okay, so how do you create? Either it's created by a security agreement, which I have said, and Section 6 is required to be in writing. As long as the grantor has rights in that asset, okay? Then security agreement must be in writing. All those things under the act I told you must describe the obligation in the creditor, signed by grantor, describe the collateral, okay? So registration of notices. There are three kinds of notices that may be registered in the registry, MPSR registry, including the initial notice, okay, an amendment notice or a cancellation notice. The initial notice must be in English and it should include the following: the identifier and address of the grantor. So we have the initial notice is Form 3 or Rule 8. Now I wish I could have access to those rules because I don't have them and they are not on the website. I don't understand. That's not supposed to be. It's not supposed to be like this, you know. Let me just check. Yeah, let's just rely on this. Yeah. So the initial notice contains Part A, Part B, and Part C. Yeah, that's it. So Part A of the notice contains particulars of the grantor being the most important person who, who transfers, or in other words, holds the rights to that movable property. Particulars of grantor, Part A, type of grantor, individual, company, unincorporated, excuse me, and then details of the grantor. So grantor 1, the name, identifier. There is ID number, passport, registration number, KRA PIN number, date of birth, or registration in case of company, postal address, email, telephone, grantor 2, name, identifier. KRA PIN number, whatever. Then part B, category of secured creditor or the representative. Part 1, consensual. Part 2, non-consensual. 3 is particulars of a consensual secured creditor or their representative. So a consensual secured creditor or their representative, details of the secured creditor, name, identifier, KRA PIN, details of the collateral is number 4, type of collateral, there's motor vehicle, livestock, crops, documents of title, intellectual property, securities, negotiable instruments, bank accounts, all present and after required property, future proceeds, household items, furniture, stock in trade, inventory, consumer goods. So stocks are also part of this. You can be collateral, consumer goods, others. So you describe collateral, including serial number if any. So if it's livestock, you describe cows of this age, maybe this weight. I don't know how they measure cows, but whether male or female, cows or bulls. If it's sheep, if it's sheep, if it's goats, you say here period of effectiveness, the days, months, and years, maximum amount secured in case of money, currency. Has grantor's authorization been obtained? Yes or no? Non-consensual. Number 8 is non-consensual creditor. Okay, you say the type of creditor. Non-consensual, it says, wait, there's some kind of NB here. Government agency can also be the type of non-consensual creditor. That includes judgment on matrimonial property, child maintenance, civil judgment, commercial judgment. So this also includes attachments on property as a result of a decree, okay? Others specify. So type of creditor, the KRA PIN, date of birth. So non-consensual creditor, these are imposed creditors, particulars of the collateral. Okay, these types of non-consensual creditors can be, let me see, number 2, government agency, judgment creditor. Yeah, so government agency like land registries, Kenya Revenue Authority, companies, registry. Alright, so particulars of collateral, you will say motor vehicle, livestock, crops, intellectual property, negotiable instruments. You must describe the collateral. If it's on order, if it's a decree or order against that property, you write the date of judgment or decree, type of judgment or decree, amount specified in the judgment or decree. Part C, whether the registration relates to a prior security right. Is the registration relating to a prior security right? If others specify access to information by the public, Part B, request for such. So part A is is basically containing the particulars of property, particulars of grantor, and particulars of secured creditor. Now, Part B of the initial notice is about access to information by the public, where there is a request for search. Section 6, a person who intends to conduct a search of the registry records shall apply to the registrar in Form 1 set out in the first schedule and pay the prescribed fees. So I think this is due diligence on the part of the person who is registering security on that on property. Before you enter into security agreements, it would help to just conduct a search, see if the property is free from any registered security. So then the search request under Form 1, search criteria, grantors identifier, collateral, serial number, type of grantor, individual, business, company, and incorporated. Collateral serial number. This is how the search request looks like. For the section 6, you will be issued with a search certificate in Form 2 set out in the first schedule of the regulations. Form 2 proceeds to search certificate will show you the grantor, the name, identifier, address, secured creditor, their name, collateral, the serial number, the type, the maximum amount secured, and the date and time of registration and date and time of search. The registrar would have signed. So you can, yeah, I don't think there's anything extraordinary here. So what is this identifier we keep hearing? The grantor identifier is the ID number. If it's a natural person who is a citizen, if it's a foreign, is the valid passport number. If it's a company, it's the registration number. If it's not incorporated, but it's an organization, is the registration number of incorporation. Oh, sorry, it is the registration number of that is issued by the relevant authority, and if not, registered by the principal officer's ID number. So they haven't left anything unaddressed here. Everything here is provided for. So what happens when there's a priority, like other people have already, the property subject to a pre-existing security on competing security? The priorities according to time of registration. So first come, first serve. A security right created by a grantor is subordinate to a security right in the same collateral created by another person if the grantor acquired the collateral subject to the security rights created by the other person and made effective against third parties before grantor acquired the collateral. Irrelevance of knowledge of existence of a security right. Knowledge of the existence of a security right in favor of another person on the part of a secured creditor does not affect its priority. So if as a secured creditor you did know, it does not affect its priority. That is why there's a search request form here, which you fill Form 1 just to exercise due diligence. Then you get your Form 2 search certificate. You will know whether there is a pre-existing security created by another, entered into by another creditor. Alright, Form 3 is the notice. Then there's this whole thing of non-consensual creditor being that they have a priority over security rights if they have registered a notice with the registrar before security right is made effective against third parties. That is how they acquire priority. Now, negotiable instruments. Enforcement over security. What are the remedies of a grantor in case of default? Remedies of the secured creditor in case of default, section 65. If the debtor fails to pay or perform the secured obligation, grantor and the secured creditor may exercise any right provided in the security agreement. So in the security agreement, you will also include, it's like a form of contract, I would say. You include, it's a contract because you are agreeing to terms. Okay, so you would include default remedies in case of default. The provider and underwriter law, Part 7 of the Act on Enforcement of a Security Act. We'll look at this, section 67. Yeah, so section 67 of the Act talks about enforcing in case of default. And it says this, let's see. So enforcement, a secured creditor may exercise their post-default rights by an application to a court of law or exercising his or her rights under the security agreement without applying to a court. So if it's contained in the agreement, a clause specifying any remedies in case of default of payment, that is what will be followed. The creditor can sue for payment. Under the agreement can appoint a receiver of the movable asset and can list the movable asset, can take possession of movable asset, can sell it. Okay, so these are not foreign remedies because just like when you when you pawn an item, ukiweka property kwa rehani, you need some cash. When you default, you don't return the money. Of course, the person on a sale to recover the monies can lease it if it's something leasable, can take possession and come to take the the property. As they can sell, they can sue. Yeah, so nothing extraordinary here. I think you ask what is this suing about? The suing is most likely applicable when it's an obligation, like when you secure the performance of an obligation. So you sue them for specific performance. The grantor is personally bound. Collateral is insufficient. Given credit is deprived of the whole or part of the security. Okay, so you can see the remedies under section 67 are clear as day. You sue, you appoint a receiver, you lease, you take possession, you sell, just like the remedies under a charge in the Land Act, section 90. So you can imagine there's nothing extraordinary here to see. Yeah. Now, methods of exercising post default or procedure by clean securing relief. Then there are rights of redemption. Rights of redemption, section 69, a collateral may be redeemed by any person whose rights are affected by the enforcement process, is entitled to redeem by paying or otherwise performing the secured obligation in full, including the reasonable cost of enforcement. So you can redeem. It's the same like a charge. You can redeem that property before the hammer falls if the sale is by auction of the property subject to charge, and when the judge is exercising their right to sell, okay, you can redeem at any time before the hammer falls in the auction, and you can pay the full amount. Section 69, the right of redemption will be exercised until the asset is sold or otherwise disposed of, acquired, or collected. So you have that time to redeem that, to exercise your right to redeem. Okay. So we have some question here. Oyeyanya, your client and friend, wishes to expand his wholesale business at Olari Trading Center, where he has rented several shops and a warehouse. Okay. He owns many properties in and around the county. For example, he has shares in at least 5 blue chip companies and debentures in several other corporations, all with a market value of not less than Kenya shillings 15 million between Gengo and Kajima ports. Oyeyene also dabbles in cotton farming and keeps over 10 tractors, 3 trucks, and vans. He tells you that he has approached an agricultural finance corporation which insists on adequate collateral for a loan of Kenya shillings 35 million. Advise Oyeyene on at least 4 types of documents he may use to borrow the loan, and by way of explanation, outline to him which of his properties, if any, he may use as collateral. So the guide, it's not clear whether or not Oyeyene has any other property apart from the movable property itemized in the question. So if he has, okay, so I think there was no mention of land here, so we'll leave it out. Now, on the other hand, okay, he may use his movable property as security for loan to the extent of the value of such property under the, okay, this is quoting the Churches Transfer Act. Okay. So I don't know why they kept the answer here using the old act, but you would use now the movable property security right to answer this question, because we see tractors are vehicles. Yeah, we have tractors, we have all these trucks, we have shares, which we said stock is also can also be a collateral. We have debentures. Yeah. Okay. Okay. So that is what he will use to create a security agreement. So the document I'm aware of is a security agreement, which will be perfected by registration of the initial notice to the register. Okay. Now, That is what I would say. So we have the initial notice and the security agreement. The others I don't know. And this book only contains like the initial notice. Let me see if there are other kinds. No, just the initial notice. So those are from 3 initial notice. I wish I had access to the rules. I would find out more myself. Just see. Hmm. Okay, let's do some. Oh, sorry. Let's do some experiment. So they have you register or what do you call? You file the notice on e-citizen. We just get in and try. Let me see. It's the business registration service on e-citizen. Do I even remember my login details? Oh, I don't remember. Hmm. I remember. Now, BLS, let's see, business registration service. Yeah, so under the business registration service, there's the collateral registry in PSR, there's the insolvency practitioners, and let's just go to the collateral registry. There's a search request option or initial notice option. So mm, it's asking what is your reason for canceling? Um, we just say search request, granted identification, motor vehicle, chassis number. Oh, interesting. So if you click on initial notice, they ask you particulars of grantor, just like the way the form is, yeah. But I can't put any details. What if it gets registered? Hmm. So it's the first thing you put is particulars of grantor. I don't want to continue. So that's it, how or where you make the initial notice. Yeah, so it's on collateral registry and the e-business, registration of business services. It's interesting. Okay, now so you can see when you're putting details on the initial notice, it just comes. The first is particulars of grantor, and I believe it moves on as you key in the details. Oh, excuse me. What else? What else? Hmm. Mhm. So the registration of security is instant. It can allow for such as registration of security, amendment of security, and cancellation. That is why we have those three types of notices: the amendment notice and cancellation. Okay. So in order for you to submit the initial notice, you must have an account on eCitizen. Then you get into the business registration and you then fill in the details to submit the notice. Yeah, so that is on NPSR. There's another question. Yeah, so this question, Mr. Fanya Kazi, a large-scale farmer, wishes to secure a big loan from a finance corporation for further development of his business. He informs you that although he owns the current land on which he carries on farming and animal husbandry, it is charged to a bank which has kept his title deed as security for another loan he had taken earlier. He has several barns in the farm in which he keeps thousands of tons uh, tons and bags of various crops, as well as hundreds of ruminants. He owns 10 tractors and 3 combine harvesters. He confides in you too that he has some cash in the bank to finance part of the development plan. Now advise Mr. Fanyakazi how else, if at all, he may use his possessions as collateral to obtain a loan in the absence of land. So already when land is exempted, you have the application of MPSR for the movables, okay? Then you say, so you just say advice, that's 5 marks. How will he may use his possessions, how to create a collateral. So obviously you explain he can use that through creating a security right as provided for by the Movable Property Security Rights Act. You will explain that I would personally explain the uh, definition of security right, what it means according to the Act. I would say it's the creation of a property right on a collateral, okay, for the to secure payment of a loan or to secure performance of an obligation. Then I would continue and say that this security right is created by a security agreement in which the grantor and the grantor signs, in which it identifies the grantor um, and the secured creditor and identifies the property. So I would say the tractors, the crops, the livestock, all of them can be used as a place the monies in the bank, yeah, the cash in the bank. So all those I will say, I would describe them, and then it has to be in writing, and of course the requirements in the section 6 that he needs to have ownership rights to this. all of them. Then, yeah, what else can you say really, except that you create a security agreement? Then explain by way of a brief draft the requirements and essential contents of any document you may have to execute. The first document is the security agreement, which under Section 6 have to be in writing, must identify the grantor, must have him sign, must identify the collateral, must identify the secured creditor. If it's an obligation, it must describe the obligation. Then I would say, oh, by way of a brief. So you use the style of a brief, you draft the requirement and essential contents of any document he may have to execute. So the second document that he has to execute would be the contents of any document. I'm just thinking of the security agreement. I don't know if he will also sign the notice. Let me see on the side. There's no place for him to sign the emission notice, so I don't think he will sign. Okay. All I can think right now is the, what do you call it, the security agreement. Okay. So yeah, those are examples of questions that can come. Yeah, so I think that concludes our topic. Let's see, what else do we have here? Let me just check the out and see if the regulations are anywhere close. I wasn't able to find them. I don't understand. Normally on Kenya Law Reports website, the subsidiary legislation is given there. So yeah, I'm not seeing the rules in detail. Let me just search for them manually. Yeah, I found them, the general regulations. So it just says the registry is electronic. The submission of the notice and the such request shall be by electronic, which we looked at. The person who needs to submit the notice must have an e-citizen account. You log in, then you get to the business registration service, the collateral registry. Then you will see whether you are making a request, a search request, or you are, what do you call, you are making a search request, or you are submitting an initial notice. And if you are submitting an initial notice, you give in the details, okay, of the grantor and everything. Now, a person may access the registry if that person has established the user account and enter the required information in the designated field. Submission of a notice is a registrant may submit a notice to the registrar if that registrant has complied with Regulation 4. The registrar shall register a notice to a registrant who complies with these regulations. Okay. Now, request for search. If you intend to conduct a search of the registry records, shall be submitted. If a person who intends to conduct a search of the registry records shall submit a search request in Form 1, which we looked at. It's basically the grantor's identifier, and is the search request, the grantor's identifier, collateral serial number, the yeah, and that's it. It's not like a lot type of grantor identifier. Yeah, that is it. Then we looked at it says here in the regulations. Notices that don't require authorization of grantor. The registration of a notice with respect to a right of non-consensual creditor. And we say non-consensual creditor can be those like the judgment creditor, where there's a decree for attachment on property, and that property now has to be registered. The notice has to be submitted. Of course, there's no requirement for consent because it's by a court order. Now, the registration of an amendment notice to add the transferee as the new grantor in accordance with the 7 of that shall not require. So, registration of an amendment of notice. We just look at section 37. Yeah, so there's a limit as to the period the effectiveness of registration will last, that is not more than 10 years, and the maximum amount secured is also some of the information you're going to include in the, what do you call it? You're going to include in the notice, and then you'll be given a confirmation of registration of the initial notice in Form 4 set out. A confirmation of registration of initial notice and Regulation 3 shall include the date and time when the registration became effective, a grantor identifier and name, where the grantor is a natural person who is a citizen of Kenya is using the ID number. We said this, yeah? Where is a company, the registration. Where it is some an incorporated organization, it is the registration number issued by that authority. If not registered, the principal officer's ID. In case of foreign, the passport. Where is a foreign company? Is the registration in the certificate of compliance. If it's yeah, so it's the registration. Not a citizen of Kenya, the passport. So what else do we need? Nothing. Okay, secured creditor will 10, where secured creditor is a natural person who is a citizen, they identify. Where it's the same, their ID number. Yeah, it's the same, except now the roles, the people are different. Description of collateral. You must describe the collateral in the notice, that is section 8. Section 8, we say the section 8. It says the assets encumbered or to be encumbered shall be described in the security agreement in a manner that reasonably allows the identification. So, must be identifiable by the description. What else do I have to say? If the item has a serial number, then we must include information required in an amendment notice. A registrant who wishes to amend an initial notice shall submit an amendment notice. The amendment notice shall contain the registration number, the information to be added or changed, and the reasons. The amendment may relate to one or more items of information contained in the initial notice. Then you will be issued with a confirmation of registration of an amendment. So it's not a certificate, it's a confirmation. Certificate is the one for search. The procedure under Rule 13 for compulsory amendment and cancellation. The grantor may, in accordance with Section 33(5) of the Act, request the registrar to register an amendment or cancellation notice in Form 7. The request under subsection shall contain sufficient evidence to enable the registrar to determine whether you are entitled to cancellation or amendment. So, and then what else? The registrar determines that the grantor has ground to request an amendment or cancellation. The registrar shall issue a notification to a secured creditor to request for amendment or cancellation, and then he responds within 14 days, and the secured does not respond, the request shall be granted. If the secured creditor disputes the grounds for granting, the registrar shall refuse to grant. Okay, information required in a cancellation. If you wish to cancel a notice, we will submit a notice in Form 9. It will contain a reason for doing so. Immediately after cancellation, you will be given a confirmation of registration of cancellation. Confirmation of registration shall include the date and time when the registration became effective and the registration number of cancellation. The fees payable shall be provided. We will look at them. Mode of delivery. Any notification shall be through the most recent electronic address provided in this. So its email address is the one here the registrar will work with. First schedule from 1 tulisema research request grantor identifier Kenyan citizen for resident foreigner Kenyan Incorporated Organization Foreign Incorporated identifier ID passport registration number collateral serial number. Form 2 is the certificate will be granted after you have requested the search, grantor identifier, name, postal, email, secured creditor, name, postal, email, collateral type, description, serial, maximum amount secured, date and time. Then we have initial notice under Form 3, particulars of grantor, type of grantor, Kenyan citizen, foreign resident, foreigner, Kenyan incorporated, foreign incorporated, foreign unincorporated, Kenyan unincorporated, details of grantor, identifier, name, postal, email. So if there's an email address, that is the one the registrar will use for communicating the notice. Then telephone, grantor 2, then when it comes to the non-consensual particulars of non-consensual creditor, if there is any, you will say. Then particulars of consensual secured creditor, you will say Kenyan citizen, foreigner, Kenyan foreign people. Then That is what it is. Then now when you come to what do you call the particulars of collateral? You say the type, details of collateral type. If it's motor vehicle, you say. If it's a trailer, you say. If it's livestock, if it's crops, if it's intellectual property, securities, instruments, deposit bank account, household items, equipment, machine, stock in trade, investment, consumer, goods, attachments, removable property, all present and acquired property. So, description of collateral, serial number of collateral, period of effectiveness, maximum amount secured, has grantor's authorization been obtained, yes or no. Particulars of non-consensual secured creditor, you will write the type. Is it an official receiver? Is it a landlord or representative? Is it a judgment creditor? Government agency? You specify details of non-consensual: name, postal, email, telephone, type of collateral, motor vehicle, livestock, crop, negotiable, intellectual securities, negotiable, deposit bank, household, machines, equipment, inventory, including stock in trade, consumer goods, attachment to movable, all present and after acquired property. This may include description of collateral, may include bankruptcy trustee, the people, the non-concession is bankruptcy trustee, liquidator, administrator, judgment creditor, civil judgment, commercial judgment, child maintenance, matrimonial, include land registries, Kenya revenue, companies, registry, serial number of collateral, date of judgment, amount of. Form 4 is confirmation. That's the one you get after submitting initial notice. It will have registration number of initial notice, particulars, grantor, type of grantor, Kenyan citizen, foreign, details of grantor, name, postal, email, telephone, identifier, non-consensual. Okay, we say who they are, Statement creditor, we have the registrars and whatever. So everything is here. Alright. Landlord, official receiver, government agency, all of them. Form 5 is amendment notice, registration number, confirmation notice, reasons for amendment. For example, reason: registered notice contains information that exceeds scope of the grantor's authorization. The security agreement has been revised to delete some collateral. So if you are deleting some collateral, you're removing it from the security agreement, transfer of security right to a new secured creditor. Okay. Particulars of the amendment. Form 6, confirmation of registration of amendment. Form 7, grantor's request for registration of amendment. The notice is in Form 8. The registrar write to, let's say, to let's say the creditor is who? I can't think right now. To Maembe Limited Company, something like that, or to Diamond Trust Bank, or to some financial credit service operator. Insert the address of secured creditor, take notice. So take notice that on the dash day of dash, the grantor requested amendment cancellation of the just notice registration number this and registered on the dash pursuant to section 33 of the Movable. In section 33 what is this? Did we look at it? 33 compulsory registration of an amendment or cancellation. Okay. So normally the secured creditor is the one who registers the amendment of the cancellation on the reasons that if it's an amendment, the registered notice contains information which exceed the scope of grantor's authorization, that the security agreement to which the registered notice relates has been revised to delete some collateral, and then security agreement to which the registered notice relates has been revised. The security agreement has been revised to delete some collateral, to remove them. If it's a cancellation, the grounds will be the registration of an initial notice was not authorized. Excuse me, that the registration was not authorized, but the grantor has, withdrawn in, and no security was concluded. The security right to which the notice has been extinguished, and the secure has no further commitment to provide value. Okay, so the secured creditor shall not charge or accept any fee for complying with this registration if any of the conditions and so set out in subsections 1 and 2 is met. The cancellation notice, the grantor may in writing request. So the grantor will request in writing to the secured creditor to register the amendment or cancellation. If he fails to comply within 10 days, then he will approach the registrar to register, and the registrar will notify the secured creditor, and before proceeding, appeals from the decision of the registrar shall lie with a court of competent jurisdiction. Because you see, those properties vary and the value also varies. So the matter of jurisdiction as to pecuniary jurisdiction in case of the maximum amount secured will vary also, like 7 million and below, then it's the magistrate's court. If it is more than, it will be the high court. Okay, I think we stop here. We are done with the regulations. From 9 is the cancellation notice, where I told you under section 33. And, okay, so yeah, that is basically what happens in the creation of these things. And the cancellation notice under section 33 is given in form 9, where the registrar, where the grantor approaches the registrar directly after the secured creditor does not register. So he will approach, and then this form is the notice the registrar will send to secured creditor, who must reply within 14 days, otherwise he will continue on registering. The reasons for cancellation and the registration number. The registration was not authorized, the registration was, but then it was withdrawn and no security agreement was concluded, security right has been extinguished. Now, from 10, a confirmation of registration of a cancellation notice is what you get. Okay, and those the submission of such request is shilling 500, but the others they haven't said. So that is it on MPSR. Bye bye and see you.